Hello everybody, welcome to another video from www.freedqinfo.com. This is the case of Donald Bailey. This is a very fascinating and incredible case, and I'm going to go into detail about it. So let's talk about Mr. Bailey here. Mr. Bailey was disqualified apparently for hypertension. That's not really that important. What is important is that the Civil Service Commission affirmed the decision. So basically, Donald Bailey, he was DQ'd, and then the Civil Service Commission, they decided to agree with the decision to DQ him, and they affirmed the decision. And note, it is signed by Simon P. Gordine, the commissioner. All right. And over here, they talk about the medical standard used by Department of Sanitation. We further note that the blood pressure readings for applicant are elevated and a serious concern. And basically, they write that there's enough evidence, the evidence before us establishes a rational basis for the conclusion of Department of Sanitation that applicant is not medically suited for the position of sanitation worker, and the determination below is affirmed. And it's signed by Simon P. Gordine, and of course, two other people that I don't think are no longer there at Civil Service Commission, but we do have the Rudy Washington, so he's still at Civil Service Commission. All right, so what does Donald Bailey do? So he gets the affirmation, and at that point, he's supposed to file an Article 78, but he does not do that. So what does he do? He gets his lawyer to basically write a letter to the Civil Service Commission, and he basically explains that Mr. Bailey donated blood recently, and he got 3 letters from 3 politicians basically attesting to, Donald Bailey's character and his service with the Boy Scouts. All right, so let's take a look at the letters. So here we have the 3 letters from the politicians. All right, we've got one from the City Council of New York. All right, that's Joseph Adabo. We have one from the Assembly, State of New York, all the way from Albany, from a Anthony Seminario. And then we have the 3rd letter from the Senate, from the State of New York. And we have Senator Surfin Maltese. All right, so basically, Mr. Bailey knows 3 politicians, and he was able to get these 3 letters which he submitted to the Civil Service Commission after the decision was affirmed. All right. And lastly, the last piece of document that Mr. Bailey submitted was his recent blood donation. So based on these 4 pieces of paper, primarily the 3 letters from the politicians and his blood donation, the Civil Service Commission decided that, this constitutes new evidence. So here we go. Here's a letter from the Civil Service Commission, and it basically says, in light of the recent blood donation, this commission is compelled to reopen the hearing and allow applicant an opportunity to testify, as this letter constitutes new evidence. This is absolutely unheard of. Nobody has ever gotten this type of treatment from the Civil Service Commission. All right, let's look at their next letter over here. The commission has reviewed Ms. Sullivan's correspondence and the arguments. After a thorough review of the file and all submissions, this commission will reopen the hearing and allow applicant an opportunity to testify. Again, this is completely unheard of. Now, what does this mean? Well, basically what the Civil Service Commission has done is they've set an example. In legal terms, that's called agency precedent. The agency has set a precedent that even though a person was disqualified, and even though the Civil Service Commission affirmed that decision, if, in the case of Mr. Bailey, you can get 3 letters from 3 politicians and maybe blood donation or some other evidence, then that will constitute new evidence enough to reopen the case. All right, so here we have, look, scheduled a new hearing. So Civil Service Commission decided to schedule a brand new hearing. Now, who authorized this? Well, look who it is. Simon P. Gordine. This is the same guy who issued the affirmation document. All right. So the same person that affirmed the decision is now saying, okay, we're going to reopen the case and have a hearing because Mr. Bailey submitted 3 letters from politicians and his blood donation. All right. So here we go. Here's the notice of the hearing. And it says, based upon this review, this commission finds that the record presents factual issues. Okay, the factual issues is that Mr. Bailey knows 3 politicians, all right? Probably 99.9% of everybody else who's a civil service applicant does not know 3 politicians. I mean, I certainly don't, all right? Therefore, an evidentiary hearing will be held. So the point of the story is that if you know 3 politicians and can get letters from those politicians, then guess what? Simon P. Gordine or somebody at the Civil Service Commission will reopen your case. Now, here I want to point out to a letter from DCAS. Basically, they're upset with the fact that Civil Service Commission reopened the case. And I'm going to have this entire letter uploaded to the website, but I want you to pay attention to this last page. And basically, here's what they say. Look at the underlined section. The Civil Service Commission has opened the door for any applicant who receives a decision from CCSC that is not in his or her favor to continue to attempt to submit new information months and years after that decision. Well, guess what? Everybody who got an illegal disqualification letter, they now have new evidence from my website. All right, so you guys are welcome to use that new evidence, all right, to basically reopen your cases and have those affirmations changed into reversals, because everybody else who got the illegal disqualification letter is entitled to a reversal. So based on the evidence of the reversals which were issued due to procedural defects simply because of the illegal DQ letter, therefore this means that you guys can now submit this as new evidence and get reversals in your cases too. All right. And you can do this because of the Donald Bailey case. And basically, Civil Service Commission, they set precedent. It's agency precedent now. Donald Bailey, he submitted new evidence. They reopened it and they issued, a new decision. Now, of course, it's a little bit more complicated, but at least I have opened the door for everybody who has gotten an illegal disqualification to now submit new evidence to get that disqualification overturned simply because the disqualification was illegal. Now, let's go to the best part of the Bailey case, which is when the Bailey case was taken to court by DCAS over the fact that the Civil Service Commission decided to reopen the case. So the judge made a decision, but the judge really couldn't do much because guess what? Bailey's exam expired. So there's a recurring theme here with everybody who gets a reversal is that the exam always expires. And as I've said in previous videos, and of course in future videos, that even though you get a reversal, it's pretty much pointless and meaningless because A, the exam will probably expire and you won't get hired. B, you're going to receive the 1 in 3 letter from the agency. Or C, the agency is just going to issue a brand new disqualification letter. So let's take a look at what the judge had to say about this. So let's see here. Based on 7 blood pressure measurements, the Civil Service Commission initially found that Bailey suffered from disqualifying hypertension. However, after reaching its determination, the commission reopened the proceedings and ordered a new test. All right. The Civil Service Commission made its decision on the basis of new evidence. The purported new evidence consisted of letters from 3 elected officials, none of whom possessed medical credentials, who attested to Bailey's service with the Boy Scouts and his good character. All right. The affirmation in opposition signed by the Commission's General Counsel, the same individual who made the disqualification determination appealing from, is mainly conclusory. Finally, this is my favorite part of the judge's decision. Although the Civil Service Commission's decision appears to have been made on the basis of political requests and incompetent opinions, the court is constrained to dismiss the petition as moot. Why? Because the examination expired. So again, the story here is that decision was made on political requests and incompetent opinions. Thank you for watching, and I will have more videos regarding this topic.